Folks, hello and welcome to Tavern Chat. I'm your host, Eric Tenkar, your bartender in the OSR, and this is something I referred to earlier yesterday in the bonus video where we talked about Ernie Gygax's apparent spamming of every community, including this channel, with the what a grifter is and we're not grifters and all that other excuse. Last night, we did a live stream on Talking Crit, myself, Bad Mike, special guest Skeeter Green. It was probably one of the most watched live streams ever on this channel. Really do appreciate the participation from all the commenters watching live, including one Erika Reich. Now, that name struck out immediately when I saw it, because first off, it told me I was mean against everybody, and that I was a liar. Because I know who usually says that when they're a few sips into the bottle. But I was like, this is the account, at least. This is the account of Justin LaNasa's wife, and it went on to tell me I was lying about the 43K judgment, and some people thought I was referring to Satine Phoenix, Satine Phoenix and Jameson, and one of their, revelations about them having an issue with a lawsuit. But no, I was talking about unpaid sales taxes on an oxygen bar and Justin LaNasa, and I referenced it briefly. Figured I would follow it up today, but I didn't think I'd be following it up today in response to air marks, quotation marks, right? Just Erika Reich, aka most likely Justin LaNasa, saying, "You're a liar, you're a liar, you're a liar, pants on fire." So, what do I have up on the screen? And by the way, yes, I know you can fucking read it, so thank you. State of North Carolina, County of Wake, Office of Administrative Hearings. Justin LaNasa, petitioner. Now we're going to have to go over why he's a petition, but we'll get there. Versus North Carolina Department of Revenue. Respondent. Department of Revenue. Give me your money. It's the tax man. Decision on summary judgment and final decision. Now, why would it be a summary judgment? Well, if you don't actually give any evidence other than what the state gives, the state only has one amount of evidence. So, this respondent had a motion for summary judgment filed with the Office of Administrative Hearings, OAH, on January 7th, 2002. And after careful consideration of respondent's motion for summary judgment, you're going to see that there was a request for documentation that was not answered. Judgment and for good cause shown, the undersigned hereby grants such motion. And they list the lawyers. Not a lawyer that I remember seeing for Justin, but maybe another childhood friend. During the audit period, petitioner maintained a North Carolina sales and use tax certificate of registration under his Social Security number. Respondent calculated the gross receipts from the oxygen sales and sales tax owed on those receipts, and it issued proposed assessments against petitioner for the tax he had not collected or remitted on the oxygen, plus applicable penalties and interest. So what happened here is that the state said, we believe you own X number of dollars, and Justin LaNasa, as the petitioner, filed and said, I don't owe the money. That's why he's the petitioner. He's petitioning that he didn't owe the money. All right. So we've talked about losing bets before. Attached respondent's motion for summary judgment is Exhibit A. So respondent conducted a conference with petitioner, and on June 2nd, 2021, before issuing a notice of final determination affirming the proposed assessment. Notice of final determination dated June 2nd, 2021 is also attached. Petitioner timely initiated this contested case, naming both Port City Vapor, Cava, and Oxygen Bar, LLC, now defunct, and petitioner LaNasa as petitioners. It was in November of last year. The tribunal amended the caption to clarify only petitioner LaNasa as the vapor, kava, and oxygen bar as no longer. On November 10th, responded email petitioner's counsel discovery requests. All right. Petitioner did not respond. The discovery period expired on January 3rd. Now, I am not saying that this is going to follow a similar pattern when it comes to the case against Wizards of the Coast. We don't know. But on January 7th, 2022, respondent filed a notice of deemed admissions with this tribunal and a motion for summary judgment. Why would that be? Well, because Justin, and it is Justin, it's no longer his LLC in question, Justin did not forward any evidence to the contrary. Therefore, the issue whether petitioner's sales of oxygen were subject to the sales tax during the period of May 1st, 2015 through April 30th, 2018, the audit period, wound up that there was no contrary evidence. Therefore, it was decided against Justin. Okay, I'm not going to read all the legalese. They'll tongue-tie me. The uncontested facts during the, because remember, the only facts is from the audit the state did. During the audit period, petitioner was registered with respondent as a sole proprietor, doing business as Port City Vapor, Kava, and Oxygen Bar. During the period, petitioner sold oxygen, among other things. The oxygen was produced by petitioner using air pumps. Then they talk about what it was. Petitioner did not collect sales tax on the oxygen sales. A few more details. None of the petitioner's oxygen customers provided petitioner with a prescription for oxygen purchased. Because apparently in the state of North Carolina, if your doctor or dentist gives a prescription for you to receive oxygen, no sales tax on it. But that's not the case here. So, based on the volume of oxygen sales, petitioner was assessed $31,374.21 in unpaid sales tax, $5,543.62 in interest, computed to October 23rd, 2020, which leads me to believe there might be a little bit more there, and penalties of $7,843.55. So I'm actually glad that Erika / most likely Justin pointed out that you're right. I didn't lie. I misstated. When I said approximately 43,000, I was off. I certainly was off. I apologize. Thank you for calling me on that. The actual number was $45,128 and some odd cents. I think 38 to be exact. So I would want to make sure that nobody here is thinking that I was trying to lower the obligations that Justin has required to pay to the state of North Carolina. I didn't want to take that away from him. I didn't want to disempower Justin or anything of that sort. So it was important enough for Justin to pop onto the live stream, or Erika. And you will not see there. If you go to yesterday's live stream, I will share it as a pinned comment to this post, this video. If you go to the live stream, you're going to see people referring to comments by Erika, and you're not going to see it in that little live stream thing along the side. However, you will see it on the screen, because anytime I saw a comment and I put it up on the screen, it's saved there. Because I believe what happened is after trolling, they then unsubscribed from the channel. So, by the way, talking about subscriptions, if you enjoy what I do, if you enjoy what this channel does, which is I bring receipts. All right, people say I talk shit. I certainly do. I'm not going to say I don't. I bring receipts. I got a receipt right here. You can find this in full at tenkarstavern.com. That will be up around the same time as this. And, if you enjoy this, if you respect it, please subscribe. If you don't, if you think that I'm full of shit, if you think that I am wrongly picking on somebody that you like, I don't apologize for it, but I can understand your feelings. Don't subscribe. Give this a downvote. That's okay. Nobody sees the downvotes anyway, which is stupid, but it is what it is. Folks, other than that, listen, we are still in the midst of the world of COVID. Use your common sense. I'm not your father, not your mother. I'm not going to hold your hands. Be safe, be well, God bless. Roll those dice, roll them well, and God willing, tonight, 9 p.m. on the Discord server, we're doing a weekly hangout in the Speakeasy from 9 to 11-ish. Tomorrow night, live stream, 8 p.m. Eastern, myself, Glenn Hellstrom. And Saturday, 8 p.m., live stream with myself and Rach. So, things to think about, folks. Again, if you can, subscribe. We appreciate it. Thank you.